Welcome to the Expert Network Team podcast,
where our goal is to inform and educate our listeners on matters related to finance, legal, insurance, accounting, and other interests that are of personal and business nature.
We hope you will find our content useful as well as entertaining.
First, to quickly introduce the Expert Network Team, here's Karl Frank.
Thanks, Mike. My name's Karl Frank with A&I Financial Services. We work with a small number of successful families to help you grow and protect your investments and choose how you want to be taxed. Now let me introduce Jeff Kromendijk.
Thanks, Karl. Jeff Kromendijk with Security First Insurance Agency, where we exist to build long-term mutually beneficial relationships with business owners as well as household members in helping them transfer and manage their risk. So, Mike, tell us a little bit about yourself.
Thanks, Jeff. This is Mike Miller with Miller & Associates CPAs. We're a small firm specializing working with small businesses and individuals to help them become tax compliant and tax efficient and help them prepare and manage their financial statements accordingly so they understand how their business is being run. We try really hard to make sure that we put more money in people's pockets rather than in the government. Next up, Nate.
I'm Nathan Merrill. I am a founding partner of Goodspeed Merrill. Goodspeed Merrill is a law firm located in the Denver Tech Center. Small business, full service oriented, as well as private client. My emphasis is on strategic tax planning, helping make sure people keep more of what they make so they can make more out of what they keep. Now I'll turn the time back over to Karl.
We hope you enjoyed the information contained in today's podcast and find it useful. If you'd like to learn more or desire to meet with any of the Expert Network team members in person, you can contact us at info@expertnetworkteam.com. That's info@expertnetworkteam.com.
We encourage you to take advantage of a free consultation with any of our team members. Just mention this podcast when you schedule your appointment.
Now on to today's podcast.
Well, hello everyone, and thank you for joining us on the Expert Team podcast. This is Karl Frank, and with me today I have Nathan Merrill with Goodspeed Merrill. And our topic for today is a power of attorney readiness. Now, power of attorney is a subject that is very important for all of us to know a little bit more about than what we do, and it's something that often causes a lot of confusion. Nate, why don't we begin at the very basic? What does it mean to have a power of attorney?
That's a good question. A power of attorney is a legal document that grants another individual, an individual other than the person we call the principal. The principal is you, the one executing the document. It grants to another person called the agent the ability to take certain actions or make decisions on behalf of the principal. So it's basically a way of empowering someone else to make legal decisions on your behalf or take legal actions on your behalf. And they're probably actually more common than most people think. You sometimes execute powers of attorney when you set up, for example, investment accounts. Mm-hmm. There's usually limited power of attorneys associated with that because someone is taking legal actions for your account on your behalf. But when we talk about them in the estate planning context, we're usually identifying people who are going to take over personal responsibility for you when you become incapacitated or if you're otherwise unable to act. So
an important thing about power of attorney is that you can create it now, but it doesn't necessarily have to take effect now. Am I right about that?
That's correct. And there's a couple of different ways we approach that in the planning context. So it's a normal assumption that you wouldn't want to give someone the power to take over your life while you were still, have full capacity and want to be responsible for that stuff. There are some instances where, whether it be travel or, if you're a very busy person where you don't have the ability to attend to all your personal needs or you want to empower someone to do that, and that's usually in the husband and wife context.
Right.
We might allow the spouses to execute documents on behalf of each other. That's what's called an immediate power. And then the normal context, like if you were granting authority to a child or some other person to act on your behalf, should you become incapacitated, and that springs into effect at the point of incapacity, when incapacity is determined, that's what we call a springing power of attorney. And one document can contemplate both appointments. So you can have a document that appoints your spouse as your immediate agent, and then in the event your spouse is not able to act, is either predeceased or is also incapacitated or just doesn't want to, no one else will have that authority until you're determined to be incapacitated, and then it springs into effect for those later appointments.
Got it. So a POA could be something convenient for me today and also keep me safe today, but if something were to go wrong, it could keep my family safe afterwards, especially after I pass away. That's
correct.
What are the legal documents I need to put a power of attorney into place?
So there's two subjects that are often the focus of a power of attorney. There's financial power of attorney, also referred to as a general power of attorney, and then there's the medical power of attorney. And the medical power of attorney deals with decisions relating to your person, your health, your care during a health event. The financial power of attorney is a little bit of a misnomer because it doesn't just relate to financial matters. It also relates to your stuff. The examples I usually give to folks is, when you become incapacitated, someone's got to pick up your mail. Someone's got to make sure the lawn gets mowed at your house and the driveway is shoveled, because that's your personal property. That's your personal responsibility. As many of us know, even if you have young kids around the house, that stuff doesn't get done unless you're the one directing it to get done.
Imagine that.
Yeah, no. Not my kids. My kids are great. They do it spontaneously and without prompting, but some people do have that problem. Yeah, no kidding. So the financial power of attorney or general power of attorney is someone who steps into your shoes and really truly takes over the management of your life if you're incapacitated.
Great.
And these can be limited beyond the broad. In the broad context, they cover everything. They can be limited to not grant someone power to sell real estate, to engage in margin trading. I mean, they can be limited in any way that someone isn't comfortable with giving that power. But as a practical matter, at the outset, those are really usually drafted very broadly. The medical power of attorney and giving it a designation to a medical agent is giving someone the authority to, if you're incapacitated, meaning you cannot communicate regarding medical decisions, or you're unable to appreciate the significance of a medical decision, that can result from drug reactions, literally intoxication or medical intoxication. It could really relate to diminished capacity, the inability to actually cognitively understand the significance of a medical decision. Then that person would then be empowered to assist with authorizing medical procedures on your behalf, treatments, and care and placement in facilities, that sort of thing.
Now, medical power of attorney, doesn't my wife automatically have that power already?
No, and in fact, that dovetails with another document that I know we'll discuss in context of the broader estate planning, but you are a separate legal entity from your spouse, believe it or not, and your spouse has no legal interest in you other than if you're dead.
Is that right?
There are some presumptions that you can act under as an interested party in someone's health, but you have no legal right to make decisions. Like my spouse would have no legal right to make decisions for me affecting my person unless I give her that authority.
It sounds like a very important document to take
It is. And that's why these, powers of attorney are perhaps the most frequently utilized of all the estate planning document suite, because more often our lives are being prolonged in such a way, or we are, with our mobile society and encountering more and more health events, these can actually, a death occurs and it's pretty instantaneous, and then you have to go through the estate administration process. But a incapacity, especially if you consider dementia and Alzheimer's, can be years in the making. And so these documents are much more significant and important to proper management of someone's estate.
We've heard horror stories about that in the years past, and it seems to me like a document, like a medical power of attorney with all the legal changes and everything else, is something that I had written 10 years ago or even longer. Is it still valid today? Should I look at it? What could possibly go wrong if I don't?
It's still valid to the extent that you've covered the things that are potentially going to come up. It doesn't find itself invalidated just through the passage of time. What we find is that as the law develops around these areas, so do the documents. And so they cover more unique fact patterns. So whereas we were drafting documents a certain way 2 decades ago, I can tell you the forms are about 10 times longer now. It used to be a 2 or 3 page form, and now it's a 20-page form for a medical power of attorney. Maybe not quite 20, but the general powers have certainly expanded to that extent. There has been some evolution in the law where there will certainly be deficiencies, such as in the area of privacy, patient privacy, health record protections, and then some of the older documents also didn't address quite clearly how to handle long-term incapacities and placement of facilities and things like that. It really just focused on critical care and medical decisions. And
so as time has passed, things have actually gotten better.
Absolutely. You'd hope.
Well,
some things do get worse,
It tends to be that way, actually. I'm an optimist. Well,
government tends towards chaos, and the private sector we tend towards clarity and improvement.
Yeah, even if it's more legal documents. Oh my goodness.
Yeah.
So Nate, why wouldn't I just go out to the internet and buy something from one of these cheap internet places that advertises? As soon as I do a Google search, it seems like I get 1 million results up for super cheap this and super cheap that. What's up with that?
Well, first and foremost, you get what you pay for. So a lot of those documents are drafted to apply broadly. Not every state has the same statutory framework for these documents, and they're typically drafted to apply to as many states as possible broadly. So that's one reason, is you're not getting state-specific provisions where necessary. In addition, those documents may not be as comprehensive as you might get from a professional advisor.
Yeah.
And if they do provide comprehension to them, they're usually in the form of checkboxes. And so whether it's comprehension and clarity of what's being granted, you're granting someone legal rights to do things on your behalf. You want to make sure that it's clear what the limits to those rights are, and not only for that person, but for you to know that you've either granted enough capacity to that person to act on your behalf or have appropriately limited it.
It sounds like if I really want a good job, I've got to go to an expert, and the expert will know my goals and values and relationships and make something that's right for me and my family.
That's true. That's definitely true. And I would say in my years of practice, I have only had a handful of occasions where someone's come to me with the specific desire just to do powers of attorney, where we will provide more value in the context of counsel regarding powers of attorney is usually when it needs to be invoked, and there's issues with how it's being either utilized, either on a defensive side. I mean, this is one of those areas where, elder abuse has become a major concern in our communities, and it's done under the auspices of attorneys, powers of attorney that have been given to the wrong people with the inadequate degree of oversight being attached to it. And so you're finding that that's an area for potential
people can be taken
abuse.
advantage of there. It's really scary.
Yeah.
So as I'm thinking about who I want to assign my power of attorney to, are there any general guidelines for what I should be thinking about? And it could be a different person for medical than it is for the financial.
Well, that's absolutely true. And I would start with, in both instances, it's important not to think of this as a designation of distinction. Like, it is not uncommon for folks to say, well, I don't want to hurt so-and-so's feelings by not appointing them.
Right.
And if someone's feelings are going to get hurt, or if they are aspiring to this role, the those are two things to be wary of, because they're not doing it because they are concerned about your well-being. So that's the primary concern when you're thinking of who to appoint is, can this person act in my best interest? Do they have the mental and emotional capacity, if I'm incapacitated, to really step into my shoes and see the world from my perspective, as opposed to how it might impact them? There's a lot of conflicts of interest that can be exposed, particularly, not to say you shouldn't appoint children, but there's a lot of conflicts of interest that can be exposed when you do appoint children as your agents. And in addition to the conflicts of interest, there could be sibling rivalries that expose themselves, various things like that start to come out. So you really want to focus your appointment on the people who truly are the best suited to carry out that. And so when it comes to general power, financial power of attorney, it's someone who has some level of sophistication.
And confidence and a desire and ability.
Yes, and the ability to balance a checkbook is key, and understand whatever investments, strategies you put in place, how to manage your property, how to delegate, because quite often these types of long-term appointments are going to require that they not be the one managing your property and mowing the lawn and shoveling the driveway. They got to engage
other experts.
Other experts or just service providers. Understand how to get a CPA lined up for you, how to deal with the investment advisor, how to rent out the property if it's going to be a while before you come back. I mean, those are kind of sophisticated transactions that not everyone deals with in their day-to-day life. On the medical side, you want someone who both has the appropriate sophistication for those types of questions and concerns, but also the emotional stamina for dealing with those types of things. I don't know if stamina is the right word, but
I think it's probably a very strong word, because it's a really tough
we call it
set of
intestinal
decisions.
fortitude, whatever. I mean, you're going to have to make decisions, not necessarily life and death decisions. Those are more handled in the advanced medical directives and living will, but
a medical durable power of attorney is a big deal.
Yeah, they're going to have to make decisions regarding, let's just use cancer as an example, whether to do chemo, radiation, how much, narcotic type medications are applied in your treatment. Those sorts of things are tough decisions to make. You want to make sure someone who has the same attitudes about health, longevity, faith, all those things come into play.
Which is one conversation with my spouse, but a completely different conversation with anybody else, my kids or anybody else.
Right.
I might have to have a long conversation with them to prepare them.
Well, to prepare them or simply to interview them. I mean, you can if you can determine that someone holds the same set of values and beliefs as you, you can be more confident they would react the same way to the inputs that might come along in those. So
we did a good job, I think, talking about, and thank you for sharing with me some advice for how I, as the creator of these powers of attorney, can protect myself and do a good job. But what about the recipient of the power of attorney? What about the person who's going to become the agent? What kind of things should they be thinking about?
A couple of different things. So obviously this is, again, going back to it's not an honor of distinction or designation of honor or distinction in any particular way. It's a new job. It's managing someone else's life. This is, if you think about how many things you have to take care of for yourself in a day, you're now doing that for someone else. So if you've been designated, particularly for parents, because fortunately, as we age, our lives tend to become simpler, so that's fortunate. But where it may be simpler in the sense that there's not as many moving parts to daily existence, that's where the medical power and coordinating with an agent under a medical power kind of ramps up, because those are the things that are spontaneously occurring that can't be anticipated. So there's that's something to keep in mind as you're an agent, is to recognize that this isn't convenient in any respect.
It's a lot of work. It's a big responsibility. Can I be sued? Am I at risk?
Yes. Hopefully you won't be sued.
Yeah.
But can you be sued? Yes. And this is where I was saying elder abuse has become a rising area of concern. But like I said, also the sibling rivalries. If a sibling takes issue with actions you've taken because either they perceive that you're self-dealing or deriving some personal benefit from it, or they just simply don't agree with what you've done, whether it's during the life of the principal or after, there could be some exposure there, but primarily the exposure is on the fiduciary side. If you violate some fiduciary trust related to the principal, then you can absolutely be sued, whether by people you contract with on behalf of the principal or other interested parties. Even the principal, parents could come out of their incapacity and realize you sold their house and they didn't want that to happen, and they could sue. So that's why other instruments for long-term fiduciary management, like revocable trusts, are sometimes advised. And I know we'll be talking about that in another
that'll be a great
podcast.
Conversation, because there's a whole series of other documents that we should do, but it might be really good just in this podcast to go ahead and list a handful of them. Sure.
I mean, the estate of an individual exists while they're alive and while they're dead. Normally we think of estate planning as something that is death time planning, and as we've discussed today, that's certainly not the case, because the powers of attorney are two of the more critical documents to a properly established estate plan, which deal with the issues that could arise during life. So there's the financial power, the general power, which are the first documents that are usually invoked. Then you have advanced medical directives, also referred to as a living will, and this is what takes care of your wishes or designating your wishes and your intent regarding end-of-life care when death is determined to be imminent. And then when, I'll go back and say another lifetime document is the living trust or revocable trust, which is really optional, and it's not necessarily a requisite for every estate plan. But there are a couple of situations where it's generally advisable to use a revocable trust. So if that's part of the plan, then that will be both a lifetime and a testamentary death time instrument. And then there's always going to be a will, whether it be the primary dispositive instrument or just a catch-all that kind of
everything that doesn't fit into
everything doesn't fit under everything else will take care of in the will. And then there's a couple of others that sometimes come in, a declaration of disposition of last remains, or what they call final wishes document. What I often refer to as a legacy letter. Our legal documents that constitute our wills and trusts don't really take into the personal side of an estate. What you want your kids to know and remember about you is not embodied. I don't put that in those documents, and that's still very important. So there's a legacy letter that we usually recommend be part of a plan. And then, the little trinkets that you want to give away, the wedding rings, the Hummels, the teaspoon collections, the baseball cards, TVs, those sorts of things you can give away to specific individuals. That's not usually embodied in the will. Also, that's just a personal property disposition memorandum.
A separate document. Yeah.
So that pretty much makes up the typical estate plan right there.
Okay. Well, thanks for joining us again, listeners. During a break here between our sessions, we have Karl Frank with us, one of the expert team members. Karl is one of the owners of A&I Financial with his wife, Stacy Frank. And so Stacy's not here with us today, but we do have Karl, obviously. And Karl, just tell us a little bit about A&I Financial. Tell us about the history. I think it was owned by your in-laws prior and started by them. And tell us a little bit about A&I Financial.
Hey, Jeff, thank you so much. It's a pleasure to be here. Our firm was founded in Colorado in 1986 by my in-laws. I married well. It's a good retirement plan. And we helped them retire almost 15 years ago now. We're a family-owned firm. There are actually 4 partners in our firm now with a number of certified financial planners. And what we do, we work with a small number of successful families. We help them grow and protect their investments. We help them choose how they want to be taxed.
Yeah, great. Well, thanks for the brief introduction there. I'm sure there's a lot more behind the story, but in the respective time, tell us a little bit about what's unique about A&I Financial and what it is that you really feel like separates you from so many other financial planners here up and down the Front Range of Colorado, but also nationwide.
Jeff, one of the things that I'm super proud of, we're the right size. So all of our clients are like an extended family member to us. We really know who they are and what they are and what means the most to them, their family, their goals, their relationships, their values. What means the most to our clients, we really know. And then we have a very unique process here that helps us treat every client the way they want to be treated, not just a canned thing that you get from somewhere else. If the client wants it to be handled in a certain way, we do that for them. We're small enough to be able to do that. And then behind the scenes, we have some huge partners, and we have enough assets now. We're a big enough firm that we can get very, very low prices and competitive research and provide these clients an experience that's both concierge and very high tech and extremely price competitive with everybody else out there in the market.
Great. Well, I know that's why my wife and I have chosen to place our portfolio with you, and so we just really thank you for the immense amount of care that you give us and great service as well. So
Jeff, it's an honor to help you and your family.
And as far as this expert team that we've assembled over the last several years, tell us a little bit about the value that brings to your clients.
Well, the ENT has been irreplaceable for my clients. Our clients get advice from all of us about all their financial affairs. So if they need legal advice or insurance advice or tax and accounting advice or lending advice, they can get it through me, from all of you. It's just been wonderful. It gives them confidence so that they can proceed with the things that are most important to them, knowing that everything is taken care of and they've got one set of eyes. And finally, it's simplicity. So they can come in and say, hey, I want to drive my car that way and I want to retire at about this time. Can you figure out how to make the engine work? Can you figure out all the details so that I don't have to worry about it? And the answer is yes. I don't need to be the expert at everything because I can come back to you and the other members of the expert team, and you guys can be effectively the mechanics on the car of my client's retirement plan.
Yeah, great. That brings excellent value. It has to our clients, and I know it has to yours as well.
Yeah, irreplaceable. There's nothing quite like it. It's great brotherhood.
Fantastic. And tell us a little bit about where you see the future of your industry going in the investment advisor world, and just where do you see this vertical going?
Great question. I'm on the board of the National Financial Planning Association, and one of the things we do, we're figuring out and setting the direction for our entire industry. And there's two major trends going on. The first is technology is driving down prices, which absolutely helps everybody who's an investor. And the second big thing is that behavior is becoming a more and more important part of it. You can't replace a human being with a computer. So technology can only get you so far, and that'll bring down the prices, but you absolutely need a real human being to help you through tough times and to make sure that the long-term decisions that you're making have the right impact, the best impact for you and the people you care about. So those are two big trends that are going on. It's driving things to be more complex, and to have somebody to be there to make things simple is a huge value, and that's where we try to be.
Yeah, great. Well, our businesses are very similar in that the insurance industry has constantly been moving towards self-advising and certainly point of purchase online, things like that. And in a complex world, that's a big risk.
Oh, it's such a mistake you can make, isn't it?
Absolutely.
Right? I mean, you don't even know what you're looking at to look at a deck page. Half the time, people are just, their eyes are rolling. They're like, well, it's $1.50 less. I'll choose that.
Yeah, exactly.
What a mistake they could be making.
Yeah, no doubt. And finally, just in closing, tell us a little bit about yourself personally. I mean, when you're not busy serving your clients, what is it that you love to do with your family and just things that you're passionate about?
Well, thanks, Jeff. We're right in the heart of it. So we've got 2 kids still at home for a few more months, and I've only got 1 at home. So we're sending them out. We're looking forward to being an empty nester, a similar stage of life to most of us here on the expert team. And we ski a lot. Our kids are competitive skiers, so that's a huge thing for us, and sports are a big part of it. And then we also all exercise and just enjoy the Colorado lifestyle, so it's a big part of it.
Absolutely. Well, all four of us have those kind of things in common, and no wonder we all get along as well as we do.
We sure do. We share similar values.
Absolutely. Well, thanks, Karl. It's great to have your introduction now a part of this podcast, and I'm sure appreciate all you do for the expert team and for our clients.
You are very welcome. It's a privilege to be a part of it.
Awesome. Thank you.
So in the back to the powers of attorney, we've talked about the two different types. We've talked a little bit about some problems that can come up in financial, in family, in legal authority and responsibilities, and in helping choose who the agent is going to be. All of these things are a big deal. But what about when you have a blended family? What about the agent who might not know the rest of the family? How can they possibly, what do you do there? Are there legal documents or things that the creator of a power of attorney can do to help make the agent's life a little easier?
That's a good question. I mean, the issue of the legal documents and the statutes that surround these areas of law have not been customized or have not been adapted to the modern family.
Right.
So,
I mean, I think we all know folks who there's been a first marriage and then a second marriage, or and the children from either, and maybe the decedent or the incapacitated person has a desire for all the money to be split in ways that the agent might not know about if he wasn't instructed. What can we do to make that situation not inflammatory and hopefully keep this family together?
Well, to the extent possible. I don't know if this is particularly directly responsive to your question, but in general, where possible, lifetime communication is key. Now, particularly in trusts, you'll see this more than in powers of attorney. There can be an imperative of coordination where one side has to work with the other side before a decision is made.
Got it.
We can do that sometimes with powers of attorney. I try not to add too much complexity to the powers of attorney because you need flexibility to execute them. So it comes down to choosing the right people for those roles. But when it comes to long-term management, and we'll talk about this more on the estate planning side, when it deals with disposition of property to someone other than for the benefit of the person who's setting up the instrument or the trust, then you can impose, like I say, coordination or collaboration between various groups that are involved in, especially in a split family.
I really get it now. So I think what you're telling me is that the power of attorney is giving somebody whose judgment you trust the ability to make those decisions. But if you need to give them help, or if you're worried about their judgment, you can take care of that with trusts and other legal documents. Have I kind of got that right?
Yeah, or if what you're really after is giving, you name a single person as an agent to, let's say, be trustee and or agent under general power of attorney, and you want to give them a support group to kind of do that, then I can't say that we would do that on a frequent basis. But if that's a concern, then you can certainly build that into like a trust instrument where you're giving them some level of limited authority to coordinate efforts with the person who's primarily responsible. You don't want to dilute the responsibility too much, because when it's everybody's problem, it's nobody's problem, right?
Isn't that it solved? Isn't that right?
Right.
Yeah.
So you want it to be clear who's in charge and who's making decisions. You can, like, sometimes folks want to have consensus on medical decisions. I don't necessarily advise this, but they'll sometimes want all the children to at least be informed of a decision before a decision is made.
Mm-hmm.
Those are not, again, typically advisable, but clients have their own personal concerns around how these things actually transpire.
It might not be expedient or realistic. Right. I mean, there's all sorts of things that could go wrong with any sort of limitation you put on a medical durable power of attorney.
Absolutely.
Right? Yeah, that could be really dangerous.
Like joint powers. We typically will not use joint powers.
Yeah. I know on financial side, we've seen some issues with joint powers, and that can be really, really, really caustic, actually, in a family. Yeah,
joint powers, when you look at joint powers, one way to look at that is you're giving someone a veto right, because joint typically requires consensus or unanimous consent. If we want to facilitate the management of incapacitated person's estate, we might do concurrent powers where both agents have full authority to act.
Oh, okay.
That can still create conflict, but at least you don't have someone with a veto right. As long as someone's abiding by their duties, their fiduciary duties, they can execute on an action plan.
Concurrent versus joint, very different.
Yeah. Concurrent means they both have full powers to act independently and simultaneously. They can certainly run contrary to each other, but at least you don't have that unwritten veto built into the power.
Great. I've got another couple of questions. I've heard about something called a guardian and something called a conservator. Well, how does that fit into this conversation?
Kind of the same thing, just with less layers of supervision. A guardianship is functionally the same thing, if not for that it's not a permanent removal. So let me go back. A guardianship is where the actual constitutional legal rights of an individual are severed from themselves by a court. So I go in, I have a guardianship appointed over me. It removes my ability to make those decisions on my behalf and gives them to another person. It's a very serious
it is.
Court proceeding for that reason, because you're severing someone's constitutional rights from them. But functionally, they'll be doing the same things an agent would under a general power of attorney. They'll be taking care of you and your stuff.
Right.
Conservator is a lot the same way. And one other thing to go back to a guardianship, these are hour-long conversations in and of themselves at some level, but typically a guardianship is going to require some level of incapacity, medical incapacity. Whereas a conservatorship can be appointed for someone who just is really bad with handling their money. There's no required finding of incapacity under a conservatorship. You can just basically go to the judge and say, this person is squandering their wealth and they can't take care of themselves.
Right.
And if you can show that, the judge may appoint a conservator, which is a court-appointed financial durable power of attorney, basically. And that person has to then create reports and send them back. In both cases, guardianship and conservator, they have to report back to the court and account for what they've done with your stuff. But they are just more extreme versions because they're severing your right to handle your affairs, whether it be personal, medical, or financial, from you and giving those to someone else. If you needed that for some reason, the agents under both these documents would take priority in the appointment for those purposes.
There, but for the grace of God, go I. Hopefully. And my situation never needs anything like that. What happens if you don't have these pieces in place? What could go wrong? If
you don't have a medical power and or a general power, then you will end up with a guardianship or a conservatorship. Unless, and I don't recommend this. In some cases, people just, like with the financial power, they just put their kids on their accounts or something like that. That's just a recipe for disaster. Your kids have creditors too.
Right.
And once their names are on those accounts, those are assets available for their creditors to collect.
Right.
So I don't recommend that. Therefore, powers of attorneys are certainly the best way to
avoid that.
And resolve those anxieties of what happens when you become incapacitated. But if you don't have them, or if they're inadequate, then guardianships and conservatorships are the only other remedy to make sure those things are handled.
Very good. Nate, what else should I know? What should I be thinking about when I learn about powers of attorney? Did we cover what...
I think for purposes of this discussion, we've probably at least highlighted the primary concerns and issues. These are important documents. They're not super complex or sophisticated. I mean, when we start talking about the broader estate planning, there's much more things to consider. This is just more one of those recognizing it's a need and then getting it done.
Right.
That's my view of it.
It is very important. We all have loved ones and we want to protect them and we want to be cared for ourselves. And it's best to think that through in a non-emotional situation than it is to be trying to figure it out during a crisis. Yeah.
And to that point, once they are done, make sure people know where they are. We would typically say provide at least electronic copies to the people you've appointed as successors. And if you feel comfortable, again, with the idea that no one's going to take offense to who you've appointed, you can distribute them more broadly so that everybody's aware of who's in charge when this event arises.
That's good advice for a large, healthy family.
Yep.
Well, thank you, Nate, for the expertise.
Welcome. It's been a pleasure.
It's been my pleasure.
Thank you for joining us today. Hope you enjoyed the information we shared.
If you enjoyed this podcast, please feel free to share it with someone else. And join us next time.
If you want to meet with a member of the team, please contact us at info@expertnetworkteam.com. That's info@expertnetworkteam.com.
If you have special topics you'd like to hear about, please reach out to us and let us know at the same email address. Again, that's info@expertnetworkteam.com. Thank you for joining us and have a great day. Thank you for listening to this podcast. We want to remind you that listening to this podcast does not establish a client-professional relationship with any of the firms represented, nor does it constitute legal, investment, or accounting advice, and the views are those of the professionals only.
Investment advisory services may be provided through A&I Financial Services, and securities may be provided through Readiness Wealth Management.